Supreme Court of Canada expands scope of willful misconduct marine exclusion. No intent required. In a 4-1 decision, the Supreme Court of Canada recently held that the statutory exclusion for loss attributable to willful misconduct of the insured doesn't require proof that the insured intended to cause the loss. Rather, the court held that it is sufficient if the insured had a duty to know and acted recklessly in the face of that duty, even if the insured in fact subjectively believed that there was no risk of harm. In a strong dissenting opinion, however, Wagner G. held that the finding at trial that the insured had no intention of causing harm was determinative. In Wagner G's view, willful misconduct requires proof of intent, and so the majority misconstrued the concept of recklessness by finding that it didn't. While Perez-Como focused on a specific statutory exclusion under maritime law, this decision nonetheless raises the question of whether some may argue that it has general application that expand the scope of intentional act exclusion found in many other policy wordings. It also bears mentioning that the majority didn't refer to any of the oft-cited basic principles of policy interpretation, but instead chose to rely on cases interpreting the term willful misconduct in the context of, among other things, the now defunct gratuitous passenger doctrine. The majority's reason for doing so and its ramification with respect to the development of the law is in the area remain unclear. The fact Real Valley is a crab fisherman who had fished on the Lawrence River near Bay Camo for about 50 years. He is the principal of his one-man company, Perez-Como Incorporation, and operates the fishing boat Realize. M. Valley Strong begins in 2005. While fishing for crab abroad in the Realize, one of his anchors snagged something on the bottom of the river. It turned out to be a cable. It was, in fact, a fiber optic telecommunication cable co-owned by Telus Communication Corporation and Hydro-Quebec and also used by Bell Canada. Later that year, Valley visited a local museum located in a former crotch where he had occasion to look at an old map or chart. It showed a line running through the area where he fished for crab. Beside the line, the word abandoned was handwritten. M. Valley assumed that the line on the chart was the same cable he had snagged, and the trial judge put him without giving the matter a second thought. Mr. Valley concluded that this was what he was hooking with his anchor. He only glanced at it for a matter of seconds and cannot recall whether it was a marine chart, a topographical chart, or indeed what type of map it was at all. In 2006, Valley snagged the cable again. This time, however, he cut the cable with an electric saw and by one end of the cable. A few days later, while in the same area, his anchor caught the cable for a third time. He cut the cable again. The trial. Of course, the cable was not abandoned at all. Telus Hydro-Quebec and Bell Canada sued M. Valley, his company, and his fishing vessel to recover the cost of repairing the cable. At trial in the federal court, it was established that M. Valley knew that he was cutting a submarine cable at the time he cut it. It was also found from his reliance on the museum chart that he had inverted to be possibility that the cable could be in use or that it could also be abandoned. M. Valley testified that he was aware that it was possible to transmit electricity by means of a submarine cable. Thus, the lower court found that M. Valley had actual knowledge of the risk that he could be cutting a live cable. Nevertheless, the lower court also found that M. Valley believed that the cable wasn't in use at the time he cut it. Ultimately, Harrington G. found M. Valley liable in negligence for damaging the cable because M. Valley had breached his common law duty to be aware of the submarine cables in the areas in which he fished. In terms of damage, Fairley attempted to avail himself of Section 28 of the Marine Liability Act and Article 4 of the Convention on Limitation of Liability for Maritime Claim, which together places a damage cap of $500,000 on marine liability for property damage caused by ship of the size and class of the Relius. The cap, however, is inescapable wherever a loss results from a person's intentional or reckless conduct. The trial judge held that because Fairley cut the cable on purpose, this limit didn't apply. Ultimately, Fairley was found liable to pay $900,000. To make matters worse for M. Fairley, the trial judge also found that Fairley had lost the benefit of coverage under his insurance policy with Royal and Son Alien Insurance Company of Canada, because cutting the cable also fell within the wording of a statutory exclusion from marine liability insurance for willful misconduct, set out at Section 53.2 of the Marine Insurance Act. The Federal Court of Appeal dismissed an appeal, and Fairley was then granted leave to appeal to the Supreme Court of Canada. On appeal to the SCC, the court dealt with three main issues on appeal. Was Fairley personally liable for the loss? Could Fairley avail himself of $500,000 limit found in the Marine Liability Act despite Article 4 of the Convention? And was the loss caused by Fairley's willful misconduct so that it was excluded from coverage under the policy? Justice Cromwell, writing for the majority, dismissed the first issue in short order, finding that Fairley was indeed personally liable for the loss, having cut the cable himself. Second, Cromwell G. turned to the question whether the $500,000 limit of liability in the Marine Liability Act would apply. He noted that this limit doesn't apply if the loss resulted from Fairley's personal act or omission committed with the intent to cause such loss, or recklessly and with knowledge that such loss would probably result. After a lengthy analysis that touched on such issues as what Fairley actually intended or knew when he cut the cable and the purpose of the convention itself, Cromwell G. concluded that M. Fairley had not intentionally or recklessly caused the loss in question to the standard required by the convention and the Marine Liability Act, in order to deny Fairley the protection afforded by the $500,000 cap. The second issue was thus decided in Fairley's favor.